Rise. Here in the matter of Holyhead Marina Ltd and Barra and all other persons claiming or being entitled to claim damages in connection with storm error striking Holyhead Marina.
You just give us one moment, if you don't mind, Mr. Justice.
Absolutely, my lord.
We've just had, as you probably heard, one or two issues in the court.
Still too high?
That's fine.
Sure.
This is not. Oh, you need that.
But never there.
Right, forgive me.
Not at all, my lord.
You probably realise we've had a last-minute change of constitution, and Lord Justice Stuart-Smith very kindly has stepped in for Lady Justice Asplin, who's unwell this morning. So he obviously will not be as au fait with the arguments and the judgment below as would Lady Justice Asplin. And so what I would suggest is that you take your introduction to the appeal a little more lengthily than I would usually be keen to hear. Lord Justice Males and I have done our usual level of pre-reading. But over to you. But if you could just give me 1 second to sort out, because not only that, but my clerk is also unwell, and so I'm trying just to make sure I've got a screen working, which at the moment I haven't. So if you just give me 2 seconds, I apologise for this. There's no plug for this. It needs a power supply. I think that's it, yeah.
Can you do without them?
We'll have
You
to,
need
won't
them.
we? Yeah. No, that's good. All good.
You're okay.
Thank you. are cooking with gas, if that's not unfashionable these days.
Perhaps with what's starting in Glasgow, my lord. The wind turbines are turning.
Yes, so Mr. Cooper, over to you.
Thank you very much, my lord, and I'm grateful for the indication as to how familiar my lord Stuart-Smith may be familiar with matters. I had prepared a script in the expectation that I would very quickly get taken off it, so I will perhaps try and stick a little bit more closely to it, just by way of introducing matters. I appear in this matter with Mr. James Wathy, instructed by Ince & Co. on behalf of the appellants. My learned friend Robert Thomas appears with Mr. Benjamin Coffer, instructed by Clyde & Co. for the respondent. What I was proposing to do, subject to your lordship's approval, was essentially to introduce a little bit of the background to the claims, both the liability action and the limitation action that is the subject of this appeal. Turn to look at the statutory context and the statutory regime that we're dealing with. Then to look at the definition of dock, which is effectively the key issue in the appeal. And within that, I will explain both how the definitions work and why we say the judge was wrong in his ultimate conclusion. And then I want to just turn and pick up some of the points made by my learned friend in their skeleton, particularly the analogy to the position of a harbour authority, which we say is not a good analogy in this case, and then to look at the authorities and the respondent's notice. And I will very briefly deal with the relevance or otherwise of the article of Professor Tettenborn, which will not surprise you to hear I say it has no particular impact on this case. And then I'll just close by dealing with the question of multiple funds. So that's my roadmap for this morning.
Okay.
As you'll be aware, Storm Emma struck Holyhead on the Isle of Anglesey in March 2018. She did about £5 million worth of damage to yachts moored at the marina there. And we obviously say that damage was caused by negligence on the part of the respondents in the design, construction, maintenance or operation of the marina. And those claims are the subject of a separate liability action in the Admiralty Court. Now, the respondent obviously denies negligence, but have commenced this limitation action and have sought to limit their liability for the damage to a sum of about £550,000. So, and they rely to do so on the right of limitation in section 191 of the Merchant Shipping Act 1995. So in other words, they're essentially trying to limit their liability to about a tenth of the value of the damage that we say has been caused. And if they are entitled to limit their liability, as they say, then that has significance not only for the individual owners of the yachts and their insurers, but also more generally for the insurance market in terms of the allocation of risk between those who insure the liabilities of marinas and the hull insurers for yachts and other pleasure craft. And that, in a sense, is why this appeal is particularly significant, as it's the first decision on, it's the first modern decision on the interpretation of section 191. Now, as is not unusual in these circumstances, in these types of case, where the point is one of construction, the respondent made a summary judgment application which led to the judgment of Mr Justice Teare, dated the 7th of July 2020. And as I'm sure you're aware, that can be found in the core bundle, tab 5 at page 45, but I'll come to that shortly. Mr Justice Teare, as he then was, held that the respondent was in principle entitled to a declaration to limit their liability, not because he held that the marina as a whole was a dock, but because he held that individual elements of the marina, namely the floating pontoons that were used to create the structure of the marina, were individually or in combination landing places, jetties or stages, so as to bring the marina within the statutory definition of the dock. And as you'll have picked up from our skeleton argument and the grounds of appeal, it is that conclusion that we challenge. We say that it was an artificial exercise to treat the individual pontoons as forming landing stage places, jetties or stages, and that as a consequence of that artificial exercise, the judge erred in concluding that the marina as a whole was a dock. Now, just to tidy up 2 points, that is the sole remaining issue between the parties on the right to limit. We did seek leave to appeal on the question in relation to the judge's findings as to the area over which the respondent exercised authority or discharged any function for the purposes of the calculation of the available limitation fund, but permission was refused on that point. We also the judge also granted us conditional leave to defend in respect of our argument that the respondents had, by their conduct in relation to the construction, operation and maintenance of the marina, lost the right to limit, and you'll be familiar with the test that's laid down in Article 4 of the 1976 Convention on Limitation of Liability that provides for the right to break limits if the person seeking limits or their controlling mind behaves recklessly with the knowledge that the actual damage suffered will probably result. That allegation is, however, no longer being pursued. So, as I say, this issue, the one that is before your lordships today, is the crucial issue between the parties. I was going to introduce the nature of the marina that we're concerned with, and it may help first to look at paragraph 3 of the judgment. And I'm going to give you my own IT apology, if I may. This is the first occasion on which I've tried to do a hearing with electronic bundles. So if for a moment I get confused, I hope I can have some indulgence.
Well, it's greatly to your credit, Mr. Cooper, and we will bear with you.
Thank you. And it's paragraph 3 of the judgment, my lords, which sets out the nature of the marina. And I can either read it to you or invite you to read it for yourselves. But you will see that the description of the marina as an arrangement of floating pontoons for the mooring of small leisure craft, which was linked to the land by a bridge. Now, it is perhaps important to note that the bridge itself was simply a means of access to the pontoons. It was not a means of securing the pontoons in any way to the land. The pontoons were in fact only moored to the seabed using a system of chains and nylon rope. And there is evidence that that particular pontoon would never survive the wavelength or height experienced during Storm Emma. Now, my lords, sometimes it's more helpful to look at photographs. So if I could take you to the supplementary bundle.
Yes, I found those pictures helpful. Which page are they on?
And if we could turn, first of all, to page 51. It is unfortunate if you're doing this by electronic bundles, on landscape view, as it were, rather than portrait, but clearly it can be rotated. But you can see...
51?
Yes, my lord. I'm hoping that your electronic bundle indices are searchable both by page number and by tab.
Yeah.
And my lords, you will see there the arrangement of floating pontoons with an outside line of long pontoons from which vessels had to navigate round to enter the open enclosure of the pontoons. And you will see why we say that there was no connection between the pontoons and the land. And you will also see just how open to the weather this particular marina was. In other words, the marina itself would offer no protection against the elements. Any protection came from the wider defences of the harbour itself.
And why do you say no connection between the pontoons and the land when there was a connection through the bridge?
Well, my lord, there was a means of access through the bridge. There was no means of securing the structure to the land through to the land. It was only moored by floating pontoons. And that may be a relevant issue when you come to look at the question of whether or not this marina can properly be described as a pier or a jetty. Because those structures, in ordinary parlance, have a connection to the land. and either run perpendicular to or parallel to the land.
But the pontoons were secured to the sea floor and to each other.
They were, my lord, yes.
Yes.
And that is why we say when you come to look at proper interpretation of section 191, the fact that they're secured to each other means that it is artificial to break them down into individual units or combinations of individual units for the purposes of deciding whether section 191 applies. What you actually have to look at is what is this structure as a whole? Is a marina? Did it fall within the definition of dock? We say no, largely for the same reasons as adopted by the judge. And we say that is where your process of analysis for the purposes of section 191 should have ended. One didn't then need to go on and try and identify another route by which one can come within section 191, particularly when there is no evidence that the marina was being used for any of the purposes that one might otherwise use a landing stage, pier or jetty. My lord, I'll develop these arguments as I go through, but could I just invite you to look, in terms of the photographs, to look at page 52. And page 53, both of which give you an overview of where the marina was to be found in relation to the harbour more generally. And if you would like a more detailed photograph of the marina, if you go to page 152,
There's a pretty picture on 54. 152.
My lord, I think that reference is wrong. It may be that 54 will.
154 is a little map.
My lord, you have the photographs there that show you the outline of the dock, and I think I've made my points about the structure. Now, the respondent in their skeleton argument at paragraphs 15 to 19, which you find in the core bundle at page 98, expressed a note of caution about the use of the word pontoon. And referred to the fact that the respondent in its contemporaneous documents referred to walkways and breakwaters and piers. We would only make at this stage these points. How the respondent describes the breakwater and the walkways does not affect the question of whether or not the walkways are in fact piers for the circumstances of section 191, subparagraph 9. In any event, the respondent accepts that the walkways and breakwaters were themselves comprised of individual pontoons and were connected to the seabed, not to the land.
Can I ask you just to look with me for just a moment at page 154, which is, I think, part of an expert report.
My lord, yes.
And we see a sort of rubber fender fitted between the main, what is called the main breakwater, and then they talk about the main breakwater connection arrangement, and that they talk about concrete pontoons. And my understanding of a concrete pontoon is that the walkway, that upon which you walk before you get on the boat, is made of concrete, but underneath would be some kind of, I don't know,
well, my lord,
made of.
from the type of pontoons that I'm familiar with, what you normally find is you have a concrete layer. It's a bit like a box,
Yeah.
which you can see surrounded by the wooden edges,
Yes.
and in which there is a concrete upper layer, and then underneath you will have some form of flotation.
Yes.
Historically polystyrene.
Okay. That's what I was asking.
but-
What's underneath?
Yeah, well, I'm not sure what. I'm sure there are now more modern options, but certainly older docks will have pontoons will have polystyrene underneath, or variant of it. And these were polystyrene.
Which page?
Page 152, I understand, my lord.
Well, the second line up from the bottom of 152, concrete and polystyrene pontoon sections.
Oh, yeah. I'm sure the detail doesn't matter, but I just was interested how you've got concrete on top of the float.
And that is how, my lord, with polystyrene blocks fitted underneath.
Right.
And one of the difficulties you can sometimes have is that as the polystyrene gets waterlogged, the pontoons sink lower. And if you need them, I'm not going to take you to it, my lord, but this report that we're now looking at, and indeed page 152, which sets out in more detail the construction of the marina, is a report of Mr. Spaller, who was the expert instructed by the loss from Charles Taylor Adjusting, instructed on behalf of the appellants. Now, the other document that it may be helpful to look at, my lords, is the original lease for the marina premises, which should be at page 66 in the supplementary bundle. And this is the lease by which the respondent was granted a lease over the seabed area that formed the area of the marina. And if I can invite you to go through the lease to paragraph 3.12, which is on page 15 in the bundle, sorry, page 76 in the bundle, page 70, sorry, my lord, 75 in the bundle,
312, did you say?
page 14 in the report, clause 3.12, which sets out the user for the marina. And you will see there, my lord, that it is to be used for the construction, operation and maintenance of a marina for pleasure craft only, with a maximum number of 500 berths, together with car parking, boat storage and associated activities on the land forming part of the demised premises. And my lord, the point we make about that is it is very clear, if any further elucidation is required, that the business for which the marina was formed, was constructed, was to provide berthing. It was not to offer landing stages, it was not to offer facilities for the loading and unloading of goods, or the embarkation and disembarkation of passengers.
Well, but I mean, you do disembark passengers where you berth.
Well, my lord, the helm and crew of a yacht or a motorboat may get off in the same way that with any commercial vessel, when you come alongside your berth, you get off or you get on. But what it is not there for is to provide a spot or a place for the embarkation or disembarkation of passengers who are, for example, on board a yacht for the purposes of a contract for a charter. It is an ancillary activity, the getting on and off of the yacht. It is not embarkation or disembarkation of passengers within the way that it is discussed in the authorities and in the way that it was considered when these provisions were being introduced.
Would you accept that a guest who goes out for a day's sail, who is a friend of the owner but doesn't contribute to the operation of the yacht, is within the ordinary meaning of passenger, although generally not going to be a paying passenger trying to get from A to B?
Well, my lord, that raises the distinction that may be relevant to this case. It is I would accept that it is within the ordinary meaning of passenger, ordinary meaning of the word, but in the context of maritime law, when, for example, you're thinking about passengers for the purposes of the Athens Convention or the 1976 Convention, I would suggest that that individual would not be considered a passenger.
Just to complete the sequence to show how far off the pace I am, what's the position if you have a structure such as this, where commercial yachts discharge their passengers and people who happen to have a berth in the marina discharge their passengers? Is one, which is the dominant use, or does that make any difference?
Well, my lord, that might make, were that the situation, that might make the question of whether any particular element of the marina was to be treated as a landing stage more difficult. But there is no evidence of any such use of this marina for that purpose.
No evidence of commercial use.
Well, my lord, commercial use for passengers. The marina did provide berths, as I understand it, for what I think are probably best described as 2 offshore support vessels, and also for the local lifeboat. And I believe they were all moored on that long breakwater that you saw in the picture at page 51 at the outer edge of the marina.
Why does that matter?
My lord?
Why does that matter?
There was more for information than for significance, my lord.
I'll go back in my box in a moment. But is it your submission that if this lease had allowed and this marina had been used as a place used by commercial enterprises letting out their yachts to people who then went onto and off, it would fall within the definition for section 191?
That's not my submission as such, my lord, but I would accept that if that were the factual situation, then I would be in a much more difficult position in terms of arguing that elements of the marina were to be treated as a landing stage for the purposes of section 191. I accept that if you get into, if there were part of the marina that were used for the commercial embarkation and disembarkation of passengers, then on the authorities in relation to that part, I might struggle to say that it is not a landing stage.
Then, I mean, what I'm struggling about is that if you look at 1919, it looks to be a definition which is about structures, doesn't it? About the physical structure.
Yes.
Not about the use. It's not directed at use, it's directed at structure. You know, words like gridirons and piers and jetties and docks and wharves.
Yes.
So how do you immediately get into usage making a difference? I mean, your answer to my lord, if I may say so, is very telling, isn't it?
Well, no, my lord, because we say that when you look at this structure, when you look at what these pontoons, what this structure was designed and constructed for, it was designed and constructed as a marina.
Well, would it be designed and constructed differently if it were a berth for 100 lifeboats of the same size as the pleasure craft?
If it was still only being used as a berth, my lord, we would say this structure would not fall within any of the relevant elements of section 1919. And so far as my lord's question is concerned, I have to accept on the authorities that I might be in more difficulty. I don't necessarily accept that it would be a landing stage within the meaning of section 191. I hope I'm only being realistic in accepting that by reference to, for example, the humorist, and this is the one I'm going to get told off for pronouncing wrong, the Ruapeu, there is some question of looking at what were these structures intended for in terms of deciding whether they fall within the definition of section 191. And that is, in a sense, the nub of our point, which is that these structures, these pontoons, which His Lordship, Mr Justice Teare, treated as being a jetty or a landing stage were not jetties or landing stages. They were individual elements within a structure intended to provide berthing for yachts, and therefore they do not fall, neither they individually nor the marina as a whole falls within the definition at section 1919.
Well, I mean, that's a formulation that I don't remember reading in your skeleton. The pontoons were individual elements in a marina that was intended for the berthing of pleasure craft.
Yeah.
Okay.
If use is relevant, where do you draw the line between what is commercial and what is non-commercial? So you might have some of the yachts which are simply used by their owners for their own pleasure, and others which are chartered out to holiday makers or others for money.
And in that latter case, my lord, those would be commercial. But that wouldn't
So you
affect...
might have some pontoons,
or might
some,
at
some
least be
pontoons
being
which
used
were
for
commercial and others which weren't. It
But-
doesn't sound as if that's likely to be a helpful approach to interpreting the definition then.
But my lord, we would still come back to the fact that even in that scenario, the pontoons were not being used as landing stages intended for the embarkation and disembarkation of passengers. The pontoons were still part of a structure intended for the berthing of yachts, and therefore do not fall within the definitions found in section 1919. So, my lord, that was what I was going to say by way of an introduction to the marina. Should you require it for your deliberations, you will find a short chronology of the events of the night of the 1st of March in Mr Crockman's first witness statement at page 123 within the supplementary bundle. But I wasn't going to take you to it at this stage.
The actual chronology doesn't matter for this purpose.
No.
The judge describes it in paragraph 4 or something quite carefully.
Should you wish to see some of the damage to the vessels that was suffered, you can find those at page 183 in the supplementary bundle.
Well, my lord particularly might like to see that. I don't think it is. Oh, yes, 184's got a lovely picture. Not sure
And in
that-
particular, page 190 and 192.
Yeah. Yeah.
Now, my lord, so far as the claim to limit itself is concerned, can I just take you to that, which you find in the core bundle? The claim form itself is at page 1. Sorry, my lord, it is still in the supplementary bundle. I apologise. It's at page 1 in the supplementary bundle. And can I just invite you to read paragraphs 6 to 8 of the declaration provided by Miss Rice in support of the claim form. And you'll note again that there's no mention of the marina being used either for commercial purposes or to embark or disembark passengers or to load or unload goods. Instead, what is said in those paragraphs is that the purpose of the marina, or what the marina provides, is 300 berths with a variable water depth. And then it goes on to describe paragraph 8, the breakup of the marina, as including the breakup and or detachment of a number of walkway elements, berthing fingers and pontoon joints. There's no reference there to piers, jetties or landing stages. And that description of the marina as a place at which the yachts are berthed was repeated by Miss Rice in her first witness statement, made in support of the application to strike out, which you find at paragraphs 5 and 6 of the statement, which is at page 44 of the supplementary bundle. And paragraph 5 in particular describes the nature of the marina. And it is telling, my lords, that if one then moves on to paragraph 24 in this statement, that when Miss Rice for the first time refers to the marina or the floating pontoons as being capable of being described as quays, wharfs, piers, stages, landing places or jetties, that it is only still in the context of the pontoons being available as a place against which the yachts berthed in the marina lie. And that same emphasis on the purpose of the marina as being for the berthing of yachts is also found in the brochure attached to the third witness statement of Miss Rice, which, and the reference I just give you is page 256, but the reference to the berthing of yachts is at page 257.
Is your point that it's described as a berth for yachts?
My point is that it's describing the business of the marina, the purpose of the marina, as being a place for the berthing of yachts. There's no reference to any other uses. So, my lords,
I mean, it's interesting, isn't it? Because if it was a berth for yachts that were chartered, so let's say there was a big business of chartering yachts in Holyhead, which there might well be, and this was the, commercial marina where the business of a particular company had 200 chartered yachts and skippers, and passengers came on board, same yachts, same everything, but it would be a landing place. But because some of them own the yachts, and some of them presumably did charter their own yachts.
My lord, I don't want to give the impression that I accept that in that scenario the pontoons would be a landing place, because it's not. It's not a place for the temporary landing of passengers or goods.
It is because they'd be coming and going. I mean, some of those businesses, it depends on the size of the yacht, but you might only have a day's charter rather than a long-term one.
How do you categorise a person who uses his yacht every day, goes onto his yacht every day with one or more friends, comes off his yacht every day, one or more friends just happens to tie it up every day at the berth that he's presumably leased, or whatever he does?
So I would describe, my lord, I would describe that as being the helm and his crew, or the owner and his crew. But and I'm not trying to be pedantic there, my lord. What I am trying to do is draw a distinction between.
But you're having to be.
Well, I am in a sense having to be pedantic, but I wouldn't say that the word passenger particularly as it's understood within the wider context of the Maritime Conventions, accurately describes somebody who is going on board a yacht for a day out, rather than describing that, and who is merely a friend of the owner, where there is no contract, and even if there were a contract, going back to my Lord's Master of the Rolls example, I would still say that it is inaccurate to describe the berth at which the yacht is moored, or the access ways to that berth, as being a landing place. Because as we'll come to see from the authorities, look again at the humorist, landing places are places intended for the temporary berthing to load, unload goods and to discharge or take on board passengers. That is not what these pontoons were there for. That is not what the structure was designed or constructed for. My Lords, can I take you then on to the statutory regime? And you have the relevant provision is section 191, which appears at tab 8 in the bundle of authorities, page 43. And it's a provision, as I believe you're aware, that provides a similar right to limit to qualifying authorities and dock owners under the international regime that is now embodied in the 1976 Limitation Convention, which is incorporated into English law pursuant to section 185 of the Merchant Shipping Act and Schedule 7 of the 1995 Act. Now, I don't think we need to look at Schedule 7, but you do have it in the bundle of authorities should it become relevant. It perhaps is worth looking first of all in the bundle of authorities at the Act of 1900, which is at tab 6. And this is the legislation which first introduced the right to limit for dock owners and harbour authorities, and which it was done, which was done as a corollary of the extension of the right of ship owners found in section 1 of the Act to limit their liability for damage to property other than ships. And as your lordships may be aware, prior to 1900, ship owners had a right to limit, but only in respect of damage done to other ships or to property on board them, and that was found in section 503 of the 1894 Merchant Shipping Act. And there is a discussion in the judgment of the legislative process that led to the introduction of section 1 and 2 of the 1900 Act. But I think it's reasonably common ground that the rights were reciprocal, so that ship owners claiming the rights under section 1 would also be met in a situation where dock owners and harbour authorities could limit under section 2. But I want to make here a point that underlies our argument, because reciprocity featured large in the judge's reasoning. And the point I want to make this is I accept that section 1 and 2 are in a sense reciprocal rights, but they're reciprocal only to the extent that the protection in section 2 applies only to those structures that fall within the definition of dock in section 2.4 of the 1900 Act, or section 1919, subparagraph and subclause 9 of the 1995 Act. In other words, Parliament, when it enacted this legislation, decided the extent of the reciprocity that it was prepared to grant. And one shouldn't, therefore, look to artificially extend the definition of dock because of a notion of reciprocity. If a structure does not fall within the definition of dock, Parliament has already decided that reciprocity doesn't require the extension of protection under section 2, or now section 191, to that structure. And by way of background, it is clear that the purpose behind the original grant of a right to limit to ship owners was to encourage the growth of the merchant fleet, and that likewise the purpose of the modern limitation conventions was to promote international trade by sea carriage. And my lords, you take that from paragraph 16 of the judgment of Mr Justice Teare, or indeed paragraph 52 in Split Chartering and Saga, which you have at tab 29 in the authorities bundle. But I think the point is probably common ground, so unless it's of assistance to look at those authorities, I wasn't going to take you there. Now, so in other words, as the judge recognised, the original purpose of the limitation rights granted by the Act of 1900 was a commercial purpose and the operation of shipping as a business, whether that business was in the carriage of goods by sea or the carriage of passengers, or indeed whether that business was the construction and repair of ships. Now, it is right, as my learned friend points out, that neither the 1900 Act nor Section 191 exclude yachts or motor yachts, or indeed the 1976 Limitation Convention, exclude yachts or motor yachts from their provisions. I also accept that marinas operate as one form of business in the maritime leisure sector. But it is going too far to suggest, as the respondent seeks to do, and the reference, my lords, is paragraph 28 of their skeleton, that the wording of section 2 was deliberately widely drafted to include the interests of leisure craft and marinas. It was not. As I've already highlighted, and as his lordship highlighted in his judgment, the purpose of sections 1 and 2 was the promotion of the merchant fleet and to provide corresponding protection to the dock owners or conservancy authorities which served that fleet. And my lord, if authority for that proposition is needed, can I take you to the Rua Peu, which appears at tab 21 in the bundle of authorities.
What nationality is the Rua Peu? Is it New Zealand?
My lord, I must admit, in preparing for this case, that was the one of the questions I didn't research. But it sounds like it is from New Zealand.
Anyway,
I don't think the judgment tells us what the flag is, but we will check. And my lords, this was a case concerning whether or not the protection. This goes back to the question of does the protection apply to a structure by reason of geography, or does it apply by reason of the capacity in which the dock was being used? And the argument was that because the claim was brought against the repair yard in their capacity as repairers, rather than as owners of the dock at which the repairs were carried out, they were not entitled to the protection of Section 2. And the court rejected that submission and held that because the repairs to the ship were being done at the dockyard, which fell within the definition in Section 2, then the shipyard was entitled to the right to limit. But it's page 183 in the bundle, in the speech of Lord Atkinson, you will see in the the left-hand column of the judgment, a reference to a case called South London and South Western Railway Company and the Normandy, where it sets out the original purposes behind the section 505 of the Merchant Shipping Act of 1854, and says at the bottom of the page, ever since the reign of King George II, there's been a limitation of liability on the liability of the owners of ships. It's been thought a matter of public policy to encourage persons to embark their capital in ships by limiting their liability to be incurred by the loss of goods. and it was thought expedient to limit the liability because a ship might carry gold or goods of great value, and then from some trifling act or neglect on the part of the master or on the part of the man steering the vessel, the ship owner might be made subject to enormous liability. So that is why there was a limit on the liability of owners. And then the court goes on to say, the words of the judge, sorry, Lord Atkinson goes on to say, the words of the judgment apply appropriately to the owner of the dock as they do to the owner of a ship. Are not the owners of docks encouraged by the rights of limitation of liability to embark as dock owners in the trade of affording facilities to ships to load and unload and to be repaired at the dry dock? It is admitted that the words of section 2 of the Merchant Shipping Act of 1900 must be construed, if they are to be at all reasonably construed, so as to put some limit on its general language. So that, having dealt with the purpose of section 2, he then goes on to discuss, as I say, why limitation is available, because the work was done at the dock. But again, my lord, that passage just emphasises the links between the rights granted under section 2 and the purposes behind section 1 and later on the 1976 convention. So what we say is that while the wording for sections 1 and 2 may have been enough to provide protection to yacht owners and to dock owners providing facilities to those yachts, this does not mean that one should in turn stretch the definition of the word dock simply to encompass a business trading as a marina, but which does not otherwise meet the definition of dock found in the legislation. If the marina meets the definition of dock because its structure falls within the definition, then that may be a matter of happenstance, but there was no intention to provide cover to marinas generally or to give any extended meaning to the definition of dock so as to cover all forms of marina.
So, I mean, just that strikes me as important. So you would accept that a marina which was fully attached to the land in the same way as a jetty or a pier would be a dock.
Might be a dock, my lord, but my lord, can I use another example which may assist, which is this. I would accept that if a marina were purpose-built within a closed space of water, such as a former gravel pit, such as a basin that is created by the construction of walls or breakwaters, and that access to that marina is via a cut or via a lock, then that would fall within the definition of dock. But it would fall within the definition of dock, not because it is a marina, but because its structure falls within the ordinary and natural meaning of the word dock. It is an enclosed space of water with an entrance which is controlled.
So a dock in Docklands, let us say, St Catherine's Dock, for example, which might be exclusively used for pleasure craft, could still be a dock.
Yes, ma'am. Because that is a structure that as a whole is properly described as a dock within the meaning of section 191. And you're not then looking at trying to artificially identify individual elements of the structure at St Catherine's Dock as falling within the definition. The structure as a whole falls within that definition.
But that example and your answer to it focuses attention on what my lord put to you, that the section is concerned with structures and not use.
Yes, ma'am. I wasn't seeking to suggest differently. What I was suggesting is that when you look at the question of what is the structure, you have to look at what are the elements that form that structure actually being used for in terms of the structure, and they're being used to create a marina. And that marina as a whole, as a structure, does not fall within the definition of a dock. And that, my lords, goes back to, as I say, the artificiality of the final reasoning of his lordship below.
But why don't we just take out the use of the word marina altogether? Because every time you use it, it seems to me, you're bringing back the implication of private yachting use, which has formed a major part of your submission so far. But as you've just said to my Lord Justice Males, it's structure, not use. Not use in terms of private or commercial. So why don't we just look at the structures?
Well, in a sense, my lord, because the claimants, the respondent, is seeking to limit its liability as a marina providing berthing to yachts. It's not looking to limit its liability as the owner-operator of piers, jetties and landing stages. Now, my lord, and that is why I say it is wrong when you come to look at the structure to break the structure down in the way the judge has done. This structure as a whole is not a structure that falls within any of the individual definitions of landing places, jetties and piers. And in a sense, in one sense, the answer to your question, my lord, is why I'm having to address it this way, is because that is what his lordship did below. Having concluded that the structure of the marina did not fall within the definition of a dock, as the ordinary Latin meaning of that word is used, he then went on to look at whether or not it could be said that because of the use of individual pontoons, as being a place where passengers could get on and off, for example, it falls within the definition of a landing stage, jetty, or
landing place.
Landing place.
I mean, that's what I don't quite understand. I mean, why is it essential to the judge's reasoning on landing place that it was a collection of pontoons as opposed to one large structure made of concrete and polystyrene? I mean, the word landing place and the usage of the term landing place is one of the structures that seems to be defined by reference to its use.
And that, my lord, is why I say that when you come to look at the definition of pontoon, to look at how you describe the pontoons, it is wrong to describe the individual pontoons as landing places. It is also wrong to describe the structure of the marina as a landing place, because it wasn't.
As it wasn't? I mean, in what sense wasn't it?
Well, my lord, it was, in a sense, my lord, when you start using a word like landing place, you are having to look at, alongside structure, the use. For example, if one looks at the humorist, in that case, Mr Justice Wilmer defined the space on the riverbed, the place on the riverbed, as a landing place because it was where the ships came alongside to drop off their goods. So in a sense, his definition of landing place was looking at the use of the pontoon, of that particular landing place. And it's by reference to that, for example, and in fact by reference to the dictionary definition, that one does have to consider in that context whether or not to properly describe that the structure is properly described as a landing place by reference to its usage.
Do you think an ordinary person walking along the Strand who happened to call into this court would think we were all completely mad, Mr. Cooper, when we're suggesting that a place where a ship or a boat or a yacht comes into land and its passengers get off is not a landing place? I mean, we have to be a bit real, don't we?
Well, my lord, we do, and that is what I'm asking you to be, because that is why I say you have to be real. Let's look at the structure as a whole. Let's not break down the individual elements of the structure, this structure was not a landing place. It was a place to berth yachts, for yachts or other vessels to lie alongside.
Are the two mutually exclusive on your argument? So if the primary purpose is berthing yachts, then it can't be a landing place?
In the context of this structure, my lord, yes. Sorry, no, they can't. It can't, because that's...
Then, I mean, I think that the man in the street would say, why on earth not?
Well, my lord, because, and I'm afraid there one does come round to use, because when one looks at the definitions, when one looks at, for example, as I've already outlined, in the decision in the humorist, the question as to whether or not the structure was a landing place is answered by what use that structure was being put to.
Well, you keep on referring to it. Why don't we look at it?
Well, my lord, let's look at the humorist.
But your submission is that the marina was a place to berth, but not to land.
Yes, my lord. And it's in tab 22 in the bundle of authorities, my lord. And the head note says this: a warehouse built on the bed of a river or a creek and constructed with an aperture in its walls for the delivery of goods into or from the craft lying alongside is a landing place, which is included in the definition of dock for the purposes of section 2, subsection 4 of the Merchant Shipping Act, Merchant Shipping Liability of Shipowners and Others Act 1900. The owners thereof are persons having the control or management of the dock and are entitled to limit their liability in respect of damage and loss to the craft and goods on board by their negligent management of the berth adjacent to the warehouse where the craft had to lie to deliver or receive goods. And so, my lord, even from that brief description, it is looking at the purpose of the place for the purposes of defining whether or not it is a landing place within the meaning of section 2, subsection 4. And if one then goes down through the judgment, my lords, it is the passages starting at the bottom of page 191, it is said by Mr. Gething on behalf of the defendants that nothing in the plaintiff's premises can be described as a dock. And then if one goes further on, onto page 192, you will see that Mr. Justice Wilmer considers the various dictionary definitions of a dock and says that the proper meaning of the word dock implies an enclosed space with gates to allow the admission and retention of water. On that basis, I think it is quite clear that the plaintiffs cannot claim to be the owners of a dock within the narrow or strict sense. But they contend that they are at least the owners of premises, which can fairly be described as either a wharf, a landing place, or a tidal basin. He then goes on to explain why he doesn't think it can properly be described as a wharf. And then halfway through the paragraph beginning with regard to the word wharf, he says, the words landing place are nowhere defined in the section of the Act. And I think that in those circumstances, their meaning has to be arrived at by common sense principles. Therefore, I ask myself whether the front of the warehouse, which is so built as to have an aperture through which for the admission of goods from craft, and which has alongside it a prepared berth in which craft can lie for the purposes of loading and unloading goods, can properly be described as a landing place. It seems to me that it is not a landing place. It is very difficult, if that is not a landing place, it is very difficult to see what a landing place could be. And he then went on to hold that it was a landing place.
Well, he holds that this particular arrangement is a landing place, but isn't the essence of his reasoning in what you've read to us that the words landing place are nowhere defined, so they don't have any technical meaning, and you just have to apply common sense in a non-technical way?
Yes, my lord.
Yeah.
But in applying those common sense principles, what he is looking at is the purpose of the particular place in question. And that is our point, that when you look at the purpose of the structure of this marina, it is not a landing place, it is a place for the berthing of yachts or other motor vessels.
But I mean, he's not defining landing place as meaning something used for the purpose of landing and loading goods. He's simply saying that something which is used for that purpose, or a structure which is used or designed for that purpose, is within landing place. So it's non-exhaustive.
Yes, ma'am.
Could you just explain? Let's say we come to the conclusion, which as you may readily understand, I'm a very long way from doing, that this is a place where yachts berth and where they land and take on people and property. Am I right in understanding that your submission is that they're excluded because either A, the primary purpose is berthing the yacht, or B, that it's not being done as part of the commercial shipping fleet?
It is certainly the first of those, my lord. I don't tie myself to it being done as part of the commercial shipping fleet, because I do have to accept that the right to limit can, for appropriate structures and indeed for appropriate ships and yachts, apply both to leisure and commercial use.
Thank you.
But what we do say, my lords, and we make this point in our skeleton, but I did want to reinforce it, is that contrary to the submission made by my learned friends, the Act in Section 1900, the definitions in the Act of Section 1900 weren't intended to apply to marinas generally. Any qualifying structure has to fall within the definition of dock. That definition was in that Act, and that definition was carried over to the 1995 Act without amendment. So we do say that in 1995, when Parliament would have been aware, not just of the existence of marinas, but of the importance of the maritime leisure sector and the role of marinas within that, they had the opportunity to take specific account of marinas within the definition of dock, and didn't take that opportunity. And so it can't be suggested, if it is being suggested, that the definition in Section 191 has to be given any wider meaning than the definition of found in Section 2 in the 1900 Act. We did do a hunt to see if we could find reference to marinas in any legislation other than various private acts. And we have given you in the authorities bundle the Capital Allowances Act 2001, which does contain references to marinas. And you have that at tab 11 of the authorities bundle. And this is defined, section 22 is a section defining the types of exclusions from the types of expenditure on plant or machinery that are relevant in the calculation of capital allowances. And my lords, it's at page 75 of the bundle, but if you then go down to page 76, you will see at item 5 a reference to excluded structures, including a dock, harbour, wharf, pier, marina or jetty or any other structure at or which vessels may be kept or merchandise or passengers may be shipped or unshipped. And if you then go on to section, the following page, section 274 through to page 80, you will see that when in that section Parliament comes to define the dock, they don't include reference to marina, and they don't include as a purpose for those structures the keeping of vessels at any of those structures. And so, my lords, what we do suggest is that had there been any intention to widen the definition in 1995 for the purposes of bringing marinas generally within the 1995 Act, that is something which Parliament would have done, and they haven't, and one is still left with the strict definitions found in the 1900 Act. So, my lords, I was then going to take you to section 191 and just take you through it, but from our discussion so far, I have the impression that you are alive to its provisions. But if it would help your lordship,
no, even I have read that.
So we then turn and come through to the definitions themselves, and I was just going to start with dock, because we say the judge was right to exclude the marina, in this case, from the definition of dock. But of course you do have the respondent's notice which challenges that decision. And we say that we have to accept that the definition of dock found in section 191 does extend the definition of dock beyond its ordinary and natural meaning. Nevertheless, the provisions found, that the list of items found within section 191 still have to be construed, even if the list is non-exhaustive, by reference to the nature of other items listed within the definition, and of course against the background to the introduction of the right to limit for docks, which was the encouragement of the commercial fleet. And that is why we say you should not be inclined, simply on the basis of reciprocity or otherwise, to give a wider meaning to the definition that it is intended to bear. We've already looked at the humorist, my lords, and so I do of course urge the conclusions of Mr Justice Wilmer in that case on you, that the ordinary and natural meaning of the word dock is an enclosed space with gates to allow the admission and retention of water. Nor does the present does the structure we are concerned with fall within the definition of dock found in the Oxford English Dictionary, which you will have on page 333 of the authorities bundle. An artificial basin excavated and built round with masonry, fitted with floodgates, into which ships are received for the purposes of unloading or loading, or for repair. And you'll then see below that, my lords, a brief explanation of dry or graving docks, and wet docks. And to similar effect, my lords, is the definition found in the concise Oxford English Dictionary, which you have at page 420 of the bundle. If you go down through to page 422, which describes a dock as an enclosed area of water in a port for loading, unloading and repair of ships. And to similar effect, the definition in Brodie's Dictionary of Shipping Terms, which you have at page 425 in the bundle. Now, the respondent places particular reliance on the definition found in the Encyclopaedia Britannica, which is at page 426. But the point that we would make, subject to hearing what my learned friend has to say about this definition, is that it still principally describes a dock as being an artificially enclosed basin into which vessels are brought for inspection and repair. And even though it does, at the bottom of page 427, refer to floating pontoon docks, of which few have been built and rise and fall with the water level, it is still talking about a structure secured to the land, and it is not suggested that these types of docks do away with the requirement for enclosure. And of course, it doesn't describe them simply as a dock. It describes them as a floating dock. And the same can be said, the same problem for the respondents is also found when they rely, at paragraph 30 in their skeleton, on the definition of marina found in the Oxford English Dictionary, which you have at page 410. Now, all this definition really tells you is that some docks and some marinas can fall within the definition of a dock within section 191, but it's not providing any general definition of marina that suggests that it has to be considered as a dock, even in the ordinary and natural meaning of the word. And my lord, the authorities also, sorry, the respondent also relies, in relation to its challenge to the judge's decision on the meaning of the word dock, on the case of the Environment Agency in Paul Barras, which you have in the bundle of authorities at tab 28.
Could you give me the page number, please?
Which is page 301.
Thank you.
And this was a case, not...
This is Lord Justice Limbaugh's case, is it?
Yes, my lord.
Yeah.
And as you may have picked up, my lord, this is a case concerning whether or not the waters within the marinas in question were to be considered part of the River Thames for the purposes of licensing. And it's therefore concerned with the Thames Conservancy Act of 1932, and in particular section 4, rather than the 1900 Act or indeed the 1995 Act. And the real question for the court in that case was whether or not the marina situated within a separate gravel pit could be considered as falling within the definition of any other works within the meaning of section 4. But the point I want to make about these cases is that these illustrate, although I don't necessarily accept that the marinas in question would have fallen within the definition of dock, simply because we don't know enough about them. But what I do suggest is that these illustrate the difference between the marina in this case, which on any view cannot be considered a dock, as discussed by Mr Justice Wilmer in The Humorist, and the types of marina that might more closely fit, similar to St Catherine's dock, within the definition of dock, because they're built within an enclosed basin of water, and there is an separate access to that basin of water through a cut. So far as my learned friend relies on this case, we say it doesn't help him. Now, my lords, that deals with the definition of dock more generally. Can I turn to move on with the other definitions? I don't think it can... no sensible argument that the marina in this case was a lock, cut, entrance, dry dock, graving dock, gridiron, or gridiron. I can expand on what those are if it's necessary, but from what was said earlier, I believe your lordships have in mind what those different structures are. You have definitions for each of slip, quay and wharf in your bundle, and slip is found at page 358 in the authorities bundle. And the marina, and indeed the pontoons in this case, cannot fall within the meaning of slip because there's no artificial slope of stone or other material. Likewise, if we look at the definition of quay, again, it describes a man-made bank or landing stage, typically built of stone, lying alongside, and this is at page 353 in the bundle, or projecting into water for loading and unloading ships. And again, my lord, we would say that that's not a sensible definition for this structure. And the same for wharf, which you have at page 405 in the bundle. Which again is described in terms of being a substantial structure of timber, stone, etc., built along the water's edge, so that ships can lie alongside for loading and unloading. And again, this would not be a description that fits the marina in the present case. Now, when we come to look at the options that were considered by his lordship, piers, stages, landing places and jetties, certainly the respondent seeks to suggest that the terms landing place, jetty and stage are not ambiguous. And that's paragraphs 8 and 9 of their skeleton. And in a sense, they're right about this, but not in the way they intend. The wording of the phrases landing places, jetties and stages is unambiguous, but it is unambiguous in requiring a structure connected to the land and which is individually identifiable as a landing place, jetty or stage. Now, this is not to imply exceptions into section 191 of the Act. It's to give the words their ordinary natural meaning, and also to prevent the definition in dock of a dock in section 191 being used to artificially divide up portions of a structure so as to enable reliance on the right to limit in section 191. My lords, the definition of landing place is at page 418 in the bundle. A place where passengers and goods can be landed, are or can be landed and disembarked. And in a sense, I was going to explain why the pontoons in this particular marina cannot, or indeed the structure as a whole, cannot sensibly be considered a landing place, either by reference to the definition in the Oxford English Dictionary, or indeed in the Humorist. But in a sense, much of the debate we've already had this morning has gone to that question, so I wasn't proposing to repeat myself. But what I do want to emphasise is that in the context of when you consider whether or not these structures were used as landing places, there's no evidence of any such use. Notwithstanding that the respondent sought to rely on these definitions within their statement, the only evidence put forward is as to the use of the berths as a place where yachts or other vessels can land. Now, one of the things that clearly concerned the judge, and this is paragraph 38 of his judgment, is that it would be odd if a marina made up of pontoons placed in a large disused or excavated gravel pit were within the statutory meaning of dock, while those in Holyhead Harbour were not. Now, my lord, we would suggest that that was a concern on the part of his lordship that was, in a sense, unnecessary. Because if Parliament had felt, when it drafted the Merchant Shipping Act 1995, that all types of marina should fall within the protection of Section 191, then they could easily have done so. Parliament has decided what types of structure should fall within the definition. And if as a consequence of that definition, one type of marina is formed from a structure that does not fall within the definition, then in a sense, so be it. It's not for this court or the court below to artificially extend the meaning of the word dock in order to encompass a structure that does not fall within the natural and ordinary meaning of the words used.
Just looking at the definition that you took us to, some of the examples of usage given there would, on the face of it, appear to apply to crew as much as, or perhaps even more than, passengers. Would you accept that? Waiting at the landing place for our boat to come ashore, pilots were ordered to conduct him to the most convenient landing place. Frenchmen knowing every landing place where they might raid the country, presumably. So there's nothing unique about it having to be passengers. It could be anybody.
It could be anybody, my lord. But those structures, those landing places, are landing places. They're not marinas. They're not structures intended for the berthing of yachts.
Well, somebody injured at sea and is ordered to be conducted to the most convenient landing place. That might well be Holyhead Marina.
My lord, that might be right, and that might be right then to use the description colloquially to say that is a landing place, but that is not the same as whether or not it is a landing place for the purposes of Section 191. My lord, that is one of the difficulties we have when you come to terms like landing place and so on. The language, one may, as a matter of colloquial language, use that phrase to refer simply to a place where you put ashore. But is that what is meant by the use of that phrase within Section 191? And we would say no, because that is not what this structure was intended for. And that is when it does become relevant to go back to look at what was the purpose of introducing the right to limit in sections 1 and 2 of the 1900 Act. And it's by going back to that purpose that one can then draw the distinction between the difficult types of cases that your lordship may be referring to and whether any particular structure is intended to be used as a landing place. My lord, turning to the word pier, if I may, again, the judge was right to reject the definition of this structure as a pier, and you have the definition at page 344 in the bundle. and it's on page 346 at the bottom of the page. A man-made structure of stone, earth, etc., reinforced with piles extending into the sea, or a tidal river to protect or partially enclose a harbour and form a landing place for vessels, a breakwater, a mole. Also a landing stage in the sea, or a river or lake, consisting of a platform supported on pillars and open beneath, especially a similar platform extending out to sea and used as a promenade or as a venue for entertainment. And my lords, in a sense, the example taken by my learned friends in their skeleton illustrates why this structure can't, or any element of it, can't sensibly be described as a pier. There's a vast difference between Brighton Pier as a structure, albeit the sea flows beneath it, built on piles into the sea, and this particular structure. And we do say that when you look at the combination of pontoons that formed this marina, it isn't appropriate to describe any element of them as piers within the meaning as that term was intended to be used in section 191, or indeed as they would ordinarily be understood as a normal use of that word. If I could turn to stage, which you have in the bundle at page 375. The Oxford English Dictionary suggests a raised platform or scaffold, or a platform used as a gangway, landing place, support or stand for materials. And this is at pages 379 to 380 of the bundle of authorities. And we say that this, trying to apply this definition to the pontoons or the structures that we are concerned with is simply inappropriate. Those pontoons were not there as a stage or even a landing stage. They were there to form elements within a structure intended for the berthing of vessels.
Why aren't they a gangway? You walk down them to the berth, to the boat you want to get onto. Why isn't that a gangway?
Well, we say that it's the structure as a whole. It might, in certain circumstances.
Well, that's exactly what the structure is. It's floating stages along which you walk, providing a gangway to the boats, to the yachts.
My lord, it is not. But it is not connected to the land by any substantial means.
But you wouldn't.
It's not a raised platform. And my lord, we would say that again, what one is doing is breaking up the structure into its constituent elements in a way that is inappropriate. The claim to limit in this case.
Forgive me for being so slow. Why do you say it's essential that it have a fixed connection to the land?
That is what
at landward end.
We say that's part of the definition of stage, my lord, that is typically used.
Not here it isn't.
My lord, certainly if you look at the case that my learned friends rely on, for example, as referring to stages, Jones and Environment Agency, the structures in that case were not to be treated, were secured to the land by scaffolding piles.
I thought you were relying on 380, page 380.
Yes, my lord, a raised floor, platform, sorry, let me...
G, little g, page 380.
My lord, we are highlighting it simply as one element of the description of a structure. But my lord, it goes back to my point that it isn't appropriate for the purposes of section 191 to break the structure as a whole into its constituent elements and seek to describe one or other element as a gangway. The claim to limit isn't made by the defendants because they operate gangways.
Well,
It's made because they operate berths.
Forgive me if I'm going off at a tangent, but and I'll be asked to be quiet by my lords if I am. But stage is one of the definitions of a dock. you say that a stage has as a normal definition a platform used as a gangway. To my way of thinking, this is a gangway. It's clearly a gangway to all the boats.
But my lord, that's not what the structure as a whole was is described as, my lord. My lord, I don't want to not answer your lordship's question, but equally I don't want to keep repeating myself.
No.
And my point is that.
Well, I won't go on repeating the question.
But my point, my lord, is this comes back to whether you treat the marina as a whole structure or whether you break it down into elements. It might be that if you break it down into elements, you can describe pieces of it as a gangway, but it wouldn't, for example, be appropriate to describe the individual finger pontoons at which vessels are berthed as gangways. That's not what they're there for. They're there to provide a structure against which vessels are berthed. And therefore, we say what you can't do is what the judge did at the end, is break this down into different elements. Break the structure down into different elements. My lord, just turning then to jetty as the final one of the definitions. And you have that, my lords, at page 340 in the bundle. A jetty is described as a breakwater, pier, etc., constructed to protect or defend a harbour, stretch of coast or riverbank, also an outwork protecting a pier. Well, just reading that definition illustrates why it isn't appropriate, certainly not to define the structure of this marina as a whole as a jetty, but equally not to describe the individual elements of the jetty, as individual elements of the structure as a pier. The definition again refers to temporary mooring or the use of the structure for temporary coming alongside, not long-term berthing. The respondents make quite a lot in their submissions about the fact that Mr Spawler chose to refer to the finger pontoons in the marina as finger jetties. And you see that, for example, at paragraph 33 of their skeleton. We would say that in reality this point goes nowhere. Certainly one can be sure that Mr Spawler wasn't thinking about section 191 and the definition of jetty when he wrote his report. Further, and in any event, it's clear that neither the finger pontoons nor the breakwaters in this marina meet the description given in the Oxford English Dictionary. And my learned friends have included within the bundle of authorities a case called Wood and Secretary of State, which is essentially a planning appeal and a very long judgment, so I'm not going to encourage your lordships to look at it unless my learned friend takes you to it. And all that is done within that authority is that there is a reference by his lordship to the structure as a jetty or pontoons. But what is also clear is that the judge wasn't using that language with any intention to give meaning to the structure. He was just picking up language that had been used by the parties within their planning submissions. So, my lords, unless I can help you further on definitions, I was going to move on and deal very briefly with the points made by the respondents at paragraphs 36 and following of the analogy that is to be drawn with the position of a harbour authority. We do not accept the suggestion that absent the presence of the harbour authority, the statutory harbour authority, this marina would fall within the definition of harbour found at section 313 of the Merchant Shipping Act. And if you want to look at it, my lords, you have that in the bundle of authorities at tab 8, page 46. We would say that the marina was not a structure which provided shelter to vessels berthed at her. It was only the marina's location within the wider harbour.
So what's it said to fall within here?
It's said to fall within the definition of harbour, my lord. which includes estuaries, and that definition is towards the top of page 46. Includes estuaries, navigable rivers, piers, jetties, and other works at or which a ship can obtain shelter and maintain or ship and unship goods or passengers. And then there's a definition of harbour authority. Now, in a sense, I'm only dealing with this because it's raised by my learned friends in their skeleton. And what we really say is that not only does this particular structure not fall within the definition...
This is a respondent notice point, really, isn't it?
I'm not entirely sure where it's intended to go, my lord.
My lord, it's not the respondent's notice point. It's a point we rely on to show why this attempt to narrow the definition can't be right, because it wouldn't apply to a harbour authority.
Right.
I mean, we would say that we certainly don't accept that the structure obviously falls within the definition of the harbour within section 313, mainly for the reasons I've already outlined as to why it doesn't fall within any of the other definitions we've discussed.
And you may say it needed a respondent's notice, whatever Mr. Thomas may suggest.
Well, my lord, there is that consideration.
This
It is
not
certainly
relied upon by the judge.
It's not a
part
point
of
relied
his
on.
reasoning.
Sorry, I apologise, my lord.
No,
I
no,
interrupted.
it's not relied upon by the judge as part of his reasoning, and this is a new reason.
No, my lord, it wasn't relied on by the judge because it wasn't taken below.
Anyway, well, we'll see how far Mr. Thomas gets with it, and you can come back in reply.
And in a sense, my lord, you've anticipated the next paragraph in my note, because I did have down. The point is not one that's really helpful, because in any event, the marina was situated within the jurisdiction of the Statutory Harbour Authority. It's not an argument considered by the judge, or one on which there was any evidence before the judge. And again, it's not the subject of the respondent's notice. Nor does it actually help solve the issues that you're grappling with. You can decide the issues that are before you just by looking at the definition of dock within section 191. If Parliament had intended, either in 1900 or perhaps more appropriately in 1995, to allied the definitions of harbour and dock for the purposes of both section 313 and section 191, then no doubt they would have done so. They've used different definitions. So looking at whether the dock is also a harbour, the marina is also a harbour within section 313 does not help. Nor can it be suggested that if the Statutory Harbour Authority had control over this structure rather than the respondents, that it would be because the Harbour Authority had control of this structure that they were able to limit their liability. Any right to limit liability on the part of the Harbour Authority would be a right accruing as a consequence of their role as Harbour Authority over the wider harbour of Holyhead. And equally, a point is made, well, consider what would happen if this marina were assembled outside the limits of the port of Holyhead, and if therefore the respondent otherwise would fall within the definition of a harbour authority. Well, again, we would say that's not a helpful exercise. It's introducing uncertainties that you don't need to consider for the purposes of this appeal. And again, it raises a different set of questions to the ones which arise on this appeal, which is as to the meaning of the word dock within section 191. Now, my learned friend has relied in his skeleton on a raft of authorities with references to different structures and how they're to be considered. Bearing in mind the time, I won't take you through them at the moment, I'll come back to them. I think generally the point we would make is that unless a case is actually specifically considering the wording of the meaning of dock or the application of either sections 1 and 2 of the Act of 1900 or the section 191 of the 1995 Act, then looking at what is said in those cases is simply not going to assist you, because their lordships were not considering the relevant questions and didn't have within mind the sort of nuances that we're looking at.
you're now advocating for the use of common sense, and you're quite likely to find some support for that proposition in the court.
Thank you, my lord. I'm always careful about the use of the word of common sense, having fallen rather dramatically into a trap laid by Lord Justice Ricks, as he then was, some time ago, about the meaning of common sense. But I am advocating that you need to look at the specific definitions and cases concerning those definitions. I've already dealt with the respondent's notice. The article from Professor Tettenborn, well, I have the utmost respect for Professor Tettenborn. The particular article relied on in this case, which is in the authorities bundle at tab 36, is of no use to the debate before this court. It was a blog post, very clearly written with an intention to amuse.
And when he said that the judgment was erudite, you sadly have to disagree because you say it was wrong.
I hope I can say that the two are not mutually exclusive.
Or you'd say erudite but wrong.
Erudite but wrong in relation to the meaning of pontoons. I have to be very careful what I say about the judgments of Mr Justice Teare.
Anyway, as you say, Professor Tettenborn may have been attempting to amuse.
My lord, what is very clear, rather more seriously, what is very clear, is that he has not sat back to consider the issues in any depth and provide academic commentary that might in other circumstances be useful to this court. That's all I say about the article. My lord, that leaves the question of multiple funds. And we say that if you follow the judge's conclusion through, that
multiple what?
Multiple limitation funds. You will have seen in our skeleton argument, my lord, that what we say is that what is clear from the judgment, and in particular at paragraph 44, is that he wasn't referring to the structure of the marina as a whole as falling within the definition of a landing place, as falling within a landing place. He was considering that it was the individual pontoons, or perhaps multiples of pontoons, that formed docks for the purposes of section 191. And we say that if that is right, then you are not concerned with a situation where the respondent as dock owner is only entitled to put up one limitation fund. In reality, there ought to be a separate limitation fund for each element of the marina that falls within the definition of landing stage, landing place, whatever it may be. Because, on the judge's conclusion, the respondent is the owner of multiple docks.
Where's that in your notice of appeal?
My lord.
Which page?
My lord, I'm not sure it appears. My lord, sorry, I apologise. Page 15, page 16 in the core bundle, paragraph 5.
Paragraph 5.
Thus, if it were correct that a pontoon is a landing place or stage or jetty, and therefore a dock, then logically it follows that there must be a separate limitations fund in respect of the damage to the vessels on each individual pontoon.
Yes.
And so, my lord, what we say is that what follows is that then each berth gives rise to its own fund, or each limb perhaps gives rise to its own fund. But clearly what does not happen is that there is only one fund of about 550,000. It is a multiple of that sum. And we deal with that at paragraph 25 of our skeleton arguments, my lord.
Can you just help me in my ignorance? I understand that the limit of liability is, and I'll get this wrong, but I think you'll understand what I'm trying to say. The limit of liability is defined by reference to the largest vessel that goes to the particular
area.
So on your interpretation, what would you do? For each pontoon, you'd have to work out what was the greatest size of vessel that had ever berthed there, or in the last 5 years, or whatever it was, and then that fixes the limitation. Is that right?
Well, my lord, in reality, it makes little difference because there is a minimum limit.
Okay.
So for vessels under, I think it's about 300 gross registered tons, the limit equates to about 550,000. So you wouldn't have to do that exercise.
You just say 350
You just say,
per
you
pontoon.
say 550,000. The other point, which is this, is that the dock owner, because it's the same person, the area area over which it exercises its function as the owner of any particular dock may be wider than the specific patch alongside the dock itself. And so, my lord, you may have seen from the grounds of appeal that we initially sought to appeal his lordship's finding that because of the functions exercised by the respondent under the terms of their lease, they weren't simply discharging a function over the area of the marina, they were discharging a function over the area of the harbour as a whole. And that would, of course, have allowed us to bring into play the ro-ro ferries. And then it's common ground that had we been able to do that, we wouldn't be here today because the fund would be big enough to cover all the claims. But what we are saying, so even though you are the owner of the dock, if you discharge a function over a wider area, then that wider area will be the one that is relevant for the purposes of calculating the fund. But we say even though it may be right that the respondent's area is a larger area than each individual pontoon or each collection of pontoons that represents a landing place or stage, it is clear that there are multiple docks for the purposes of section 191, and therefore a separate limitation fund accrues in respect of each dock.
Thank you very much.
My lord, I think in answering his lordship's question, I have made the points that I was otherwise going to make in relation to the application of section 191. I'm conscious of the passage of time, so I was going to draw to a close to allow my learned friend to start, but unless your lordships have any other questions.
Well, I'm just, when the judge posed the question at paragraph 34, the remaining question is whether the marina at Holyhead is within the ordinary meaning of landing place, pier, jetty or stage. I think he did answer it by saying that the marina at Holyhead was within the ordinary meaning of landing place, jetty or stage. And even though he said that the pontoons which make up the marina at Holyhead were the places where the owners of the small leisure craft moored their craft and places where people stepped on and off. So he was being very precise in a way that you're now holding him to account for, so as to, I think, exclude the bridge that connects the pontoons to the land, not itself being a landing place, which probably is right. But is he really, sorry, just let me finish, is he really saying that the marina is not taken as a whole, made up of the pontoons, a single landing place?
My lord, if one read, as I read paragraph 44 of his judgment, that is not what he's saying. Because what he begins by saying is, I have therefore reached the conclusion that the pontoons which make up the marina at Holyhead are within the statutory definition of dock, being landing places, jetties or stages. So it is the individual pontoons or perhaps collections of them. The claimants are, it is accepted, the owner of the marinas, that is, of the pontoons which make up the marina, and so are in principle entitled to the right to limit. So he is not saying that it is because they are the owners of the marina. He is saying it is because of they are the owners of the constituent pontoons.
Right, thank you.
My lord, can I just make one final point, which may not be particularly important in the overall context of things. But when you talk about the bridge connecting the pontoons to the land, I'll be corrected if I'm wrong about this, but it wasn't connected in any fixed way.
No, it's like all bridges of that kind. They go up and down.
Well, it simply sits on the pontoon. There's nothing that actually secures it to the pontoon.
Well, it either goes up and down between guides, or it goes up and down in another mechanical way. But you're right, it is connected, but not fixed.
Yeah. My lord, unless I can help you with any further questions, I hope that I have answered all that you have had.
No, well, thank you very much.
Thank you, my lord.
Mr. Cooper. Mr. Thomas.
My lords, I'm in the enviable, perhaps unenviable position of having heard your lordship's interactions with Mr. Cooper, and obviously what I don't wish to do is repeat matters which are either obvious to your lordships or which will not assist. So, as I proceed, if your lordships aren't finding what I say helpful, I do ask you to move me on as quickly as you would like to do so.
We
My
never
lords,
normally need encouragement in that direction, Mr. Thomas, but we've been very good today because we don't want Lord Justice Stuart-Smith to feel that he's completely at sea, if I can do that without intending to pun.
My lord, I sense his lordship is more than up to speed with this case already, if I may say so. My lord, my learned friend correctly identified to your lordships that this is the sole remaining issue in this particular limitation action. It's the only matter that's left to be decided. My learned friend made rather light of the fact that he said he was no longer pursuing the Article 4 case. The simple fact is that Mr Justice Teare found that to be a most improbable argument and required his clients to put up £350,000 security for costs in order to pursue it, and they didn't have the courage of their convictions. My lords, that leaves, as I said, just this single issue, and as my learned friend indicated to your lordships, obviously there's two elements in the application of the statute. First is to see what we have, and then to understand whether it fits within the definitions provided for in section 191. My learned friend took you to various pictures, photographs and illustrations of what the marina was before it was destroyed, and we do submit it's useful for your lordships to have seen that, amongst other things because this wasn't anything other, in our submission, a substantial structure. As set out in our skeleton argument, the breakwaters, as they are described, which are the two main elements going around the outside of the marina, are made up of individual units, which are some 70 tons in weight each. So each of these concrete pontoons is 20 metres long, 4 metres wide, and 70 metric tons individually.
Has the thing been reconstructed?
My lord, there was you'll see in the bundle some proposals for a new marina. I don't actually know how far that has progressed. I'm sure we can update your lordship over lunch. I think it is certainly hoped that a shiny new marina will appear in due course. But the point is,
it'll be built differently so that it's unequivocally a dock, whatever we say.
And it'll certainly be connected to the land, as I understand the proposal. I think the point I wanted to emphasise to your lordships, albeit very briefly, is actually the substantial nature of these particular items. And it plays into, as we'll come to, for instance, the definition of pier. And if I just could take your lordships to perhaps one or two photos in the supplementary bundle, and the pages I wanted to refer your lordships to are firstly 212 and then 232, which give, I think, the court a good sense of the size of these particular pontoons, particularly at 232. You'll see the substantial size of them. That is, as I understand it, the main breakwater, which we see people walking up and down by way of use as a gangway, amongst other things. So I just draw that to the court's attention. These are substantial pieces of engineering and significant structures in themselves.
Did you say 3 metres wide?
4.
4.
Your Lordship will find it summarised at paragraph
Yeah, no,
15 of our skeleton argument. And as you'll know, they're then floating walkways, and there are what are called jetties or finger jetties as well, which come off the walkways. So, my Lord, with that brief introduction, I was then going to turn to the language of the statute, albeit as briefly as your Lordships wish me to be. I do ask your Lordship just to bear in mind when we turn to the Act itself, that page, it's tab 8 of the Authorities Bundle, page 43, that the statute conveys the right to limit not just on the owners of any dock, but also on the Harbour Authority, Conservancy Authority, and the owners of any canal. And we do say that's relevant, not least because my learned friend submitted, I'm sure it was a mistake, but it's not correct, as he said, that Section 2 is limited to structures within a dock. That is categorically not the limit of Section 2. It applies to canals, to harbours, and also to conservancy authorities. And the point, my Lord, I'll come to later if your Lordship allows me, but our reference to, and the analogy with the Harbour Authority is one that we use simply to illustrate that if my learned friend were correct, the position of a harbour authority would seem to be very different to the position of a dock owner or indeed a canal owner. And I'll come to explain that in due course. But we do submit that when one looks at my learned friend's attempts to narrow down the wording of the statute, one has to stand back and look at the wider scope of the Act itself and those other persons or authorities to which it gives the same right to limit.
Well, I suppose you say none of the distinctions that he sought to draw are really found in the wording of the statute.
My Lord, that is our primary position, absolutely, on all fronts. There's no wording, as Justice Teare correctly found, no wording in the statute which seeks to draw any of these distinctions. And from our side, we are now slightly unsure of what the distinctions are that are drawn. Originally, and at the forefront of the appeal, was this notion that these structures were purely commercial ones, that were not used for leisure purposes, and my little friend doesn't seem to press that. I don't know where he now stands.
Well, I don't take him to have abandoned it, if that's what you're suggesting.
Well, my Lord, I'm sure he hasn't, but if I just show your Lordships why I say that, and I'll come to touch on it later, in his skeleton at paragraph 23, which is at page 87, he criticises the judge for looking to the fact that 23.1, he wrongly took into account the fact that pleasure craft, as well as commercial ships, are entitled to limit their liability. This is not the issue, and their primary point then is that the type of structures listed are all structures which are used in commercial, including passenger shipping, but not for mooring pleasure craft. So we'd understood there to be a distinction drawn here, an important one according to the.
But I mean, he might have, should we say, soft pedalled that, because it is so obvious that a pier and a jetty, for example, are obviously and commonly used for mooring pleasure craft.
My Lord, they are. And that's absolutely our point. And if your Lordships are with us on those points, then I suspect it is the end of the appeal. And one of the points I make to your Lordships, it's very hard to understand what the distinction now is. I'll come to it in a minute. But
well, he's been forced to use some rather difficult distinctions, like what the usage of whether the vessels are commercially used, which I think probably could be seen at a glance to require a great deal of contortion.
Well, indeed. And dare I say the new
but
point.
I do want you to deal, Mr. Thomas, with this point about breaking it down to pontoons, because I'm not sure I've quite got to the bottom of why the judge did that.
My Lord, well, if I might skip then to deal with that, bear with me for one moment, my Lord. The point is one that was not run before his lordship. I may say that, and it's important because it's not an argument that was deployed before his lordship, and we do submit that it's not at this stage a point that is open to the appellants, because it would have required, if it had been pleaded, which it was not, it would have required evidence. And I'll come to explain to your lordship why that is the case in a moment.
So what point was not run before the judge?
That each of the individual pontoons or landing places was a separate fund. Your lordships will see the defence in the supplementary bundle, starting at page 25. Essentially, 3 points were taken in the defence. One is that the point on this appeal that this isn't a dock and there's no right to limit. The second was the attempt to break the limit. And the third was the attempt to say, well, actually, the area over which Holyhead Marina had control was a wider area. And
the area included the row-rows?
Yeah.
Yes.
But they didn't plead, and there's no application to amend, to plead that each individual pontoon or each individual landing place is a separate fund, and therefore, accordingly, sorry.
But that may or may not be the reason why he's doing it, but I think he's taking a slightly different point and saying the judge broke down the marina into pontoons to find that it was a landing place, but did not find that the marina was a landing place, and therefore it's not.
He does, and as I think we sought to explain in our skeleton, that was because it wasn't an issue at first instance. I wasn't before his lordship, but I'm told by Mr Coffer that effectively the pontoon was used as shorthand. We explain that in paragraphs 17 and 18 of our skeleton argument. We say the appellants used the term pontoons to describe all the marina elements. Before the judge, the respondent was content to use the neutral term with a view to avoiding unnecessary dispute over terminology. And that's why the judge used it in his judgment.
But it's not all the elements, is it? Because the bridge is not a pontoon.
Correct, my lord. Correct.
Yeah.
But it was used as shorthand because this matter wasn't in issue, and rather than repeating on each stage the breakwaters, jetties, and fingers, it was used as shorthand.
Right. I mean, that's because the breakwaters, fingers, and jetties are all made up of pontoons constructed by concrete on top of polystyrene, right?
Correct, my lord.
Yeah,
Well,
just different sizes.
The finger jetties may not be. I think they were made of wood, but the other elements were.
Or wood on top of polystyrene.
Probably not even on polystyrene, but I'm not sure.
Okay.
It matters, my lord.
But they serve the same function.
They do, of course.
Finger jetties might be wood. Just wood.
Perhaps you would say that when he poses the question at paragraph 34, the remaining question is whether the marina is within the ordinary meaning of landing place, pier, jetty or stage. It would be surprising if what he meant when he came to his answer at paragraph 44 was no, but there are a lot of individual landing places, particularly in the context where that was not apparently a point that was live before it, and therefore that paragraph 44 is perhaps just loosely expressed, but is intended to answer the question at 34.
My lord, and that is the point I was going to make to your lordship precisely, because even if one reads 44, what he says, I've therefore reached the conclusion that pontoons which make up the marina at Holyhead constitute landing places. So he's referring back to the question he posed at 34, which is whether the marina is within the ordinary meaning of landing place, pier, jetty or
So
stage.
that could be in contradistinction to the bridge. The pontoons that make up the marina are, the bridge is not.
Well, the bridge is certainly not a landing place.
Right.
Um,
So he's answering the question he's asked.
Indeed.
And actually, it's that precision that is now said to get him into trouble when he means that the marina, insofar as it is actually the, if I can put it this way, the business end of it, is a landing place, but a landing place might also include, I don't know, steel fixings that pass into the land. They're not themselves the landing place, but they're a necessary part of it,
of course,
as the bridge is.
Indeed, my lord.
But I mean, the argument wasn't about all that.
It wasn't, my lord, and that's why fixing on this precise wording is.
I know you weren't there, but the case was seemingly extremely well argued by your juniors on both sides.
My lord, I'm sure they'll be grateful to hear that. But in terms of the point made and the picking up of the language, that, in my respect, which is important, informs your lordship of why the words were used, but also the precise question the judge was actually looking at. And in our submission, the simple answer is that the marina is a single landing place when one takes it in that context.
Yes, well, I mean, it becomes tortuous and really pointless and nonsensical to break it down so that a marina becomes something that is not within a dock because it's got a bridge which is necessary to enter it.
My lord, the bridge point, I'm afraid I simply don't understand at all. But just to finish off the point, if I may, my lord, just before lunch, the position I think is also clear if one steps back and looks again at the provisions of the Act. If I might ask your lordships to turn up tab 8. And again, this is where, looking at the wider scope of the Act, may assist your lordships. Of course, it covers canals.
Yeah.
And that there's nothing in the Act or no wording in the Act that my own friend can point to. It's just, in the case of a canal, you should walk down the towpath and count each individual landing spot or mooring place in the canal, and that the canal's liability is X times that. There's simply no wording which would lead to that result. So if we look at the wording and how it works, it provides in section 2 that the liability of any authority or person to which this section applies for any loss or damage caused to any ship or any goods, merchandise or other things whatsoever on board shall be limited in accordance with section 5 below by reference to the tonnage of the largest UK ship which at the time the loss or damage is, or within the preceding 5 years, has been within the area over which the authority or person discharges any function.
So your point here is simply that if the canal owner is only liable for one load of liability, it would be incredible if a collection of pontoons making up a marina, the owner of that structure was liable for 10, say, loads of liability.
My lord, precisely. And in fact, in this case, if one thinks about it, you've got 180 metre breakwaters, 2 of those, 9 pontoons each, then we've got 5 walkways. You'd have about 50, on my learned friends analysis, you'd have about 50 limitation
limits.
funds,
Yes.
which respectfully, I might submit, is plainly not what the Act intended, but it would put dock owners in an entirely different position to harbour authorities, to canal owners, or indeed conservancy authorities. And in our submission, one reads subsections 2 and 3. Subsection 3 provides limitation of liability under this section relates to the whole of any losses and damage which may arise on any one distinct occasion. What the Act is providing for is a single limitation figure on each occasion that applies to the whole of the area over which the authority or the dock owner or the canal owner has control. And that's what it does. So even in the language of the statute, in my submission, one gets one's answer to this. There's a single fund for the whole area over which the relevant authority or person has control. And there's not anything in the wording there, in my submission, which supports this odd contention that you should have multiple funds. My Lord, so I hope that deals with that particular point. I should say that we do formally reserve our position as to whether Mr Cooper is entitled to run this, and I say it for this reason: is it wasn't addressed before the judge below, it wasn't part of the defence, and it does in principle raise questions of fact which haven't been answered. And if I might just make good that submission, in his skeleton argument at paragraph 25.2,
Could you give me a page number?
page 89, my lord.
Thank you.
He makes the point that if it were correct that the pontoon is a landing place, then it logically follows there must be a separate limitation with respect to the damage to the vessels in each individual pontoon. So if this argument were to go forward, you'd have to assess how many vessels were moored on each pontoon. Now, these are 20-metre pontoons. It is quite possible that you might have had several vessels moored on each individual pontoon. And what one would have had to have done then is work out and have evidence as to how many vessels were on each pontoon.
And you might need to know how big the vessels were on
Indeed.
each pontoon in order to assess the limit of liability.
Indeed, and also to understand the extent of the damage done to each, to know if you can limit. There have been 5 vessels on one pontoon and £150,000 worth of damage done to each, then the limit would come into play. If there'd been 1 and it had been 100,000, obviously not. But none of this was developed or addressed before the judge at the hearing because it was never raised. So we do take if you like, a threshold point that's not in the applicant's gift to run this point now. So, my lord, that is the multiple. Sorry. That is, my lords, perhaps a convenient moment to break. My learned junior has reminded me quite correctly that we also have the point about the use of the singular dock includes jetties and piers and so forth in the wording of section 191 subsection 9, which we also submit points to the same conclusions that the dock
Piers and
includes,
landing places.
Indeed. It covers multiple landing places and jetties as a matter of language.
But
That's
in fact,
exactly-
all the things it includes are in the plural.
My lord, yes.
Just one very important point. The word landing places in section 191, I believe, has no hyphen, but the definitions appear to always have a hyphen. I assume there's no significance in that.
My lord, none that either of us have picked up on, so your lordship, I think, can assume not.
Very good.
It's a cracker.
Yes.
It's almost as good as the comma.
I now understand this case.
Good. Okay, well, we'll resume at 2 o'clock. I take it we're not going to get the whole of the afternoon.
My lord, no, I sincerely hope not.
Very good. If you just, we will rise, but it just may take me slightly longer.